Management and Insurance series of lectures. Today we'll go through session 2. I'll just bring my presentation up. I must also correct something I said in the first video, in the introduction video. I said that bridging finance became a problem in 2017. It was in fact in 2007, when we started seeing claims related to bridging finance. Today we'll start with the series where we go through the internal controls that you can consider implementing in your firms in order to mitigate the risk. And the first today's session will deal with managing the engagement with the client. You'll recall from what was said in the previous session that the failure to carry out a mandate properly and the failure to confirm instructions were highlighted as the types of errors and omissions that lead to professional indemnity claims. So this risk can be proactively mitigated by managing your relationship with clients and also by documenting that relationship. This will go a long way towards mitigating the risk in that your client's expectations will be managed, uncertainty will be reduced, and thus both the firm and the client will be protected. And one of the ways of managing the engagement and thus the risks that flow from it is to document the terms of the mandate in a letter of engagement. This is a document that sets out the agreement between the law firm and its clients. For current purposes, we'll use the term letter of engagement. There are other practices and other entities use different names for the document, but the principles are all the same. Before we get into it, it's important just to make a few comments about some of the risks that emanate from clients and some of the things you need to look out for in risky clients. First, the first one that I would mention is first clients who cannot comply with the requirements relating to FICA. That's clients that cannot give you proper documents or adequate documents which enable you to conduct a FICA verification process. When I say FICA, that in terms of the Financial Intelligence Center Act. But also beware of clients with unrealistic expectations. Clients that come to you that expect you to achieve certain things within an unrealistic time, with unpractical time, which is just not practical, or else clients that want you to achieve results which are unrealistic. Also look out for clients who have terminated the mandate of more than one legal representative in respect of the same matter before they come to you. Please ascertain, interrogate this when you interview the client for the first time and you have your initial consultation. Ask them what were the reasons for the termination of the mandates of the previous attorneys, and where it's possible, please phone your colleagues if these are lawyers you know, and ask them what was the reason for the breakdown. Also, be careful of clients who express a general unhappiness towards the legal profession and the administration of justice. These are the type of clients who will tell you how they've been hard done by lawyers and courts and quasi-judicial system in general, all their lives. It's just a matter of time before they will also add you to that list if you cannot achieve what they want, no matter how reasonable or unreasonable that is. And also be careful of clients who are heavily personally involved in the matter. Yes, a legal matter is something personal for the client. The outcome is personal, but there are clients that are just overly invested. And I'm not talking about invested in the financial sense, but who have invested their persons in the outcome of a matter. These are the type of people that want to run a matter as a matter of principle. And you'll note that a lot of times they're not just interested in what the outcome will be, but they will also want to dictate your strategy, and every step you take, they'll want to dictate what you write to the other side. And something else that another characteristic of these types of clients, these are the people who always feel that they want to prove a point to the opposition. Another red flag that you should please look out for is those clients who want to, I'll use the term, co-lawyer with you. These are the clients who want you to run everything by them. They want to dictate to you how the matter how the instruction will be carried out, and almost want to sit side by side with you. Many years ago, when I was in practice, I had a client who asked me whether he could sit second chair with me, and that is an expression that comes from people who have watched many of these legal documentaries on TV, where there's a lawyer sitting first chair and second chair. So please be careful of that. You are the lawyer, and they are the client. It's not a relationship of equals. If they feel that they are lawyer enough to deal with the matter, maybe hand it back to them for them to run it on their own. Also be careful of clients who do dump lots of documents on you. These are the people that bring you lever arch files or even boxes of documents, and a lot of that is irrelevant to the matter that you are being instructed to deal with. In some instances, they'll even bring you cutouts from the media or printed documents or from the internet of what has happened in areas that may not even be related to the instruction that you are being requested to take. Also be careful of clients who ask you what the legal requirements are for a certain point, and then want to tailor make a version that suits what you've told them in the matter. So please apply a bit of professional skepticism in speaking to your clients, or as some people put it, apply a pinch of salt. Also be careful of clients who are very demanding in respect of your time. These are the people that want constant reports, daily reports, hourly reports, just general running reports on how the matter is running. They soon take over your practice. They may even be doing that to the staff in your firm. Please speak to your staff about that, just to ensure that they aren't being bullied by clients. And be careful. Unfortunately, some clients, by their nature, become very needy people. And yes, these are all the types of people who sorry, I just had to clear a frog in my throat. These are the red flags, and these are the type of clients who turn around and sue their lawyers. And lastly, be careful of clients who are serial litigators, who have a history of litigating against lawyers or lodging complaints with the Legal Practice Council. Apologies for that. Yes, there may be many instances where a client is justified in suing their lawyers or lodging a complaint with the Legal Practice Council, but there are people that do this at the drop of a hat or almost as a part of their business. Just a last category that I'll add is be careful of in matters where you act for clients as a favor, whether this is a favor to a family member, a friend, to another client, or even to one of your colleagues in the practice. Yes, by all means, do favors, take referrals, but ensure that even in those matters and even in matters where you are acting on a pro bono basis, that the rules of engagement are the same and that you set that set the tone up front in your relationship with the client. So letters of engagement. These what you can look at it in your drafting your letter of engagement is the scope of the engagement. Set out what the firm is instructed to do so that there are no disputes later where the client says that you were expected to do certain things and you say that you were not. I know that in many instances we see that there are practices that still use a generally worded power of attorney. That is just not good enough, unfortunately, in the current environment. By all means, sign a power of attorney, but make sure that the scope of engagement is properly set out. And also, the letter of engagement or whatever term you use to describe your contracts with clients should be the first point of call. Set out, detail there what the mandate is, where it starts and where it ends. Also record who the client is, so if there's more than one, who they are. If the client is acting in a representative capacity, record that as well. Set out your FICA verification process or the checklist that you use also in that document. Explain who the servicing team is in the firm so that the client knows who to contact and then one point of contact. Setting out who the servicing team is will also assist you in, when it comes to billing, so that they know that who the senior person or persons are involved in the matter, what their charge out rate is, and the candidate attorneys and so forth. If you expect to use counsel or some other expert in the matter, that should also be set out. And fees and billing are very important. If the client is expected to pay a deposit to cover your fees before you can start working on the matter, state that in the letter so that there's no confusion later. We have dealt with a number of claims where a client says that the attorney accepted the mandate. The attorney says that that part of the agreement was that work would only commence once the attorney was placed in funds to cover fees, and the client says that that's not the case. The attorney does nothing in the matter, and then this only comes out when the attorney is sued because maybe the claim has prescribed or there has been some other consequence. So please set that out. And even though the quoted sections, the quoted portions of Section 35 of the Legal Practice Act have been postponed, please have regard to them and use them, because they contain useful information that you can be included in the in the fees, billing and expenses portion of your letter of engagement. If you are acting on a contingency fee basis, ensure that the contingency fee agreement complies with the requirements in the Act, and you can include that in your letter of engagement. In this way, you can have one document rather than several documents that are setting out the same thing. Important for purposes of cybercrime and the business email compromise scams, set out the banking details of the firm, so the client has that on record, and also those of the client. Insist that the client comes, and you can do this as part of your FICA verification. Tell them to come to the first consultation with original bank stamped documents so that they can confirm those. If you are having the consultation virtually, for example, using one of the electronic platforms, still insist that if the client has sent you documents, ask the client why their video was on, to tell you what their banking details are, and you can verify those with the documents that you have on your side. Also set out the circumstances under which the relationship can be terminated and what the consequences thereof are. So issues like whether, if there are any outstanding fees, whether you'll hold on to the file, if there are any further steps that need to be taken in the matter, whether you need to set these out. Also put in a dispute resolution clause so that if there are any disagreements while you are carrying out the mandate, how those will be resolved. You could, for example, say if a matter is being dealt with by a candidate's attorney, that it will be escalated to you. If you're acting for a company and you're getting instruction from a member of the management team, you can agree with the client that it will be escalated to someone more senior, just to try and resolve it. Because it's not all disputes that will arise that will lead you to want to terminate the relationship with the client. Sometimes these are just bumps in the road that you want to resolve. Also, if there are counterparts, so there are various other documents that set out the agreement or portions of the agreement, record those. Please explain the document to your client, sign, and also get the client to sign and return the document. We have had numerous claims where the legal practitioner signs the document, sends it to the client, or hands a copy to the client, and the client goes off with it and never signs and returns it. The next the legal practitioner hears about the matter is a few years down the line when they're being sued. So ask the client to sign it. And if over time your mandate is changing, please update that. If necessary, prepare an addendum, and once again, make sure that both parties sign and date the addendum. When you prepare your letter of engagement, explain each term to the client and ensure that the client understands. If necessary, use an interpreter to explain the terms to the client. Provide the client with a copy. Ensure that you retain the original. And when you're drafting the letter of engagement, consider the applicable legislation and the other regulatory requirements that apply in the matter that you deal with. And if we look for example, at the rules that have quoted there, those relate to written instructions, so that on receipt of written instruction from the client, the attorney must ensure that the intended scope of the engagement is set out. That's your mandate, with sufficient clarity to enable the attorney, that's the word in the rules I've added, and the client, I presume, to the full extent of the mandate. And secondly, in the event of uncertainty regarding the scope of the mandate, the attorney must seek written confirmation of the intended scope of the instruction. If you look at the rules, when it comes to investments, there are several provisions that say that investment mandates must be recorded in writing. There are a number of resources that you can also look at that are relevant to this session, and those are listed on this slide. The previous editions of the Risk Alert Bulletin are available on the LPIIF website, which is www.lpiif.co.za. If you look under the risk management page, you can get prior editions of the Risk Alert Bulletin. Also on Darebus, in the practice management column of Darebus, you'll get a lot of the information. But I've just highlighted those articles that you can please have a look at when you draft your letter of engagement. Thank you very much. That is the end of session 2. Session 3 will follow in the next video. I thank you for your time.